Hello, welcome to Study Circle. If you are preparing for any competitive exam, then this video is going to be very useful for you. So today we are going to read class 11th standard political science part 2 and chapter 2 rights in the Indian constitutions. So this video is the full summary of this whole chapter and intended for revision purpose only. So if you are doing revision, then this video is very useful for you. So, without wasting any much time, we will only read the important points and the summary of this whole chapter. So, rights in the Indian constitutions. A constitution is not only about the composition of the various organs of the government and the relations among them, but the constitution is a document that sets a limit on the powers of the government and ensures a democratic system in which all persons enjoy certain rights. So, to understand the importance of right, here we have a case study. The case study of construction workers who were denied rights. So, here is a request to all of you that if you are new to my channel, then please do subscribe. And if you liking this video, then do like, share, and also comment. So here is the case study of construction workers who were denied rights. In 1982, the government engaged a few contractors who employed a large number of a very poor construction workers from different parts of the country to build the flyovers and stadium during the construction work for Asian Games. A team of social scientists studied their poor condition and petitioned the Supreme Court. The violation of right against exploitation, that employing a person to work for less than the minimum prescribed wage amounts to beggar or forced labor. The court accepted the plea and directed the government to ensure that thousands of workers get the prescribed wages for their work. So, what is Bill of Rights? A democracy must ensure that individuals have certain rights and government will always recognize these rights. Most democratic countries list the rights of the citizens in the constitution itself. Such a list of rights mentioned and protected by the constitution is called Bill of Rights. The remedy against violation of rights is that as it prohibits government from acting against the rights of the individuals. The protection of individuals that from person or private organization and from the organs of the government such as legislature, executive, bureaucracy or even the judiciary. The fundamental rights in the Indian Constitution. History of rights. The importance of rights was realized by the leaders of the freedom movement and they demanded that the British rulers should respect rights of the people. The Motilal Nehru Committee had demanded Bill of Rights as far back as in 1928. After independence, the constitution listed the rights that would be especially protected and called them fundamental rights. So what are the importance of fundamental rights? The word fundamental suggests that these rights are so important that the constitution has separately listed them and made special provision for their protection. The constitution itself ensures that they are not violated by the government. Judiciary has the power and responsibility to protect the fundamental rights from the violation by actions of the government. Not absolute or unlimited rights, as the government can put reasonable restriction on the exercise of fundamental rights. So what are the difference between the fundamental rights and other rights? In ordinary or other rights, they are protected and enforced by ordinary law, and they may be changed by the legislature by ordinary process of lawmaking. Fundamental rights, they are protected and guaranteed by the Constitution, and they may only be changed by amending the Constitution itself. The Constitution of India, in Part 3, fundamental rights are mentioned. So, there are 6 fundamental rights, and what are they? The right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, and right to constitutional remedies. The first one is right to equality. In right to equality, there is equality before law and equal protection of laws. Prohibition on discrimination on grounds of religion, race, caste, sex, and place of birth, and equal access to shops, hotels, wells, tanks, bathing ghats, roads, etc. Equality of opportunity in public employment and abolition of untouchability and abolition of titles. Right to freedom. In right to freedom, there is a protection of right to freedom of speech and expression and assemble peacefully, form associations or unions, move freely throughout the territory of India, and reside and settle in any part of India, practice any profession or to carry on any occupation, trade or business, and protection in respect of conviction for offences. right to life and personal liberty, right to education, protection against arrest and detention in certain cases, right against exploitation, prohibition of traffic in human beings and forced labor, and prohibition of employment of children in hazardous job. Right to freedom of religion, freedom of conscience and free profession, practice and propagation of religion, freedom to manage religious affairs, and freedom to pay taxes and promotion of any particular religion, freedom to attend religious instructions to worship in certain educational institutions, cultural and educational rights, protection of language, culture of minorities, right of minorities to establish educational institutions, and right to constitutional remedies, right to move the courts to issue direction orders, writs for enforcement of rights. Right to equality. It tries to do away with caste, gender, and other discrimination and strives to make India a true democracy by ensuring a sense of equality of dignity and status among all its citizens. It provides for equal access to public places like shops, hotels, places of entertainment, wells, bathing ghats, and places of worship. There cannot be any discrimination in this access on the ground only of religion, race, caste, sex, or place of birth. It prohibits any discrimination in public employment on any of above mentioned basis. It abolishes the practice of untouchability, and also it provides that the state shall confirm no title or person except those who excel themselves in military or academic field. In Article 16, Para 4, nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class or citizen which, in the opinion of the state, is not adequately represented in the services under the state. And the preamble mentions two things about equality. First, equality of status, and secondly, equality of opportunity. In equality of opportunity, there is all sections of society enjoy equal opportunities. The Constitution clarifies that the government can implement special schemes and measures for improving the condition of certain sections of society, children, women, and the socially and educationally backward classes. So, reservations are not against equality. In Article 16, Para 4 of the Constitution explicitly clarifies that the policy like reservation will not be seen as a violation of right to equality. It was required for the fulfillment of the right to equality of opportunity. Right to freedom. Equality and freedom or liberty are most essential to a democracy. Liberty means freedom of thought, expression, and actions, but it does not mean freedom to do anything that one desires or likes. Freedoms are defined in such a manner that every person will enjoy her freedom without threatening freedom of others and without endangering law and order situation. Right to life and personal liberty. It is the foremost right among right to freedom. First, that no citizen can be denied his or her life except by procedure as laid down under the law, and secondly, no one can be denied his or her personal liberty. Next is no one can be arrested without being told the grounds for such an arrest. If arrested, the person has the right to defend himself by a lawyer of his choice. It is mandatory for the police to take that person to the nearest magistrate within 24 hours, and the magistrate who is not part of the police will decide whether the arrest is justified or not. The wider application of this right is that various judgments of Supreme Court have expanded the scope of right, such as this right also includes right to live with human dignity and free from exploitation. In Article 21, protection of life and personal liberty, that no person shall be deprived of his life or personal liberty except according to the procedure established by law. The preventive detention. Sometimes a person can be arrested simply out of an apprehension that he or she is likely to engage in unlawful activity and imprisoned for some time without following the above mentioned procedures. The reason behind is that a person can be detained or arrested if government feels that a person can be threat to law and order or to the peace and security of the nation. It can be extended only for 3 months, and after 3 months such case is brought before an advisory board for review. The criticism of preventive detention is that it is misused by the government against people for a reason other than justified reasons, and it comes in conflict with right to life and personal liberty. The other freedoms are that there are other rights under the right to freedom, but they are not absolute. each of these subject to restriction imposed by the government. Right to freedom of speech and expression is subject to restriction such as public order, peace and morality, etc. The freedom to assemble too is to be exercised peacefully and without arms. The government may impose restriction in certain areas, declaring the assembly of five or more persons as unlawful. Rights of accused. In rights of accused, in the Constitution ensures that accused person would get sufficient protection, and no one is guilty unless the court has found that person guilty of an offence. To ensure the fair trial in courts, the Constitution has provided three rights. First, that no person would be punished for the same offence more than once. Secondly, no law shall declare any action as illegal from backdate. And third one is no person shall be asked to give evidence against himself or herself. The right against exploitation. In India, underprivileged people may be subjected to exploitation by their fellow human beings, such as beggar or forced labor without payment, and buying and selling of human beings and using them as slaves. Both of these are prohibited under the constitutions. And in the constitution, the forbids employment of children below the age of 14 years in dangerous jobs like factories and mines. It became more meaningful after right to education becoming a fundamental right for children. The right to freedom of religion. According to our constitution, everyone enjoys the right to follow the religion of his or her choice. Democracy has always incorporated the freedom to follow the religion of one's choice as one of its basic principles. The freedom of faith and worship. Everyone is free to choose a religion and practice that religion. Freedom of religion also includes the freedom of conscience. A person may choose any religion or may choose not to follow any religion. So, what is freedom of conscience? That a person may choose any religion or may choose not to follow any religion. Freedom of religion includes the freedom to profess, follow, and propagate any religion. What is freedom to profess, follow, and propagate any religion? Subject to certain limitations. The government can impose restrictions on the practice of freedom of religion in order to protect public order, morality, and health. The government can interfere in religious matters for rooting out certain social evils, such as the government has taken steps banning practices like sati, bigamy, or human sacrifices. Issues with right to freedom of religion. Issue of forcible conversions. The Constitution has guaranteed the right to propagate one's religion, which includes persuading people to convert from one religion to other, but it does not allow forcible conversions. It only gives us the right to spread information about our religion to attract others. So, equality of all religions. Being a country which is home to several religions, it is necessary that government must extend equal treatment to equal different religions, not favoring any particular religion. Idea does not India does not have any official religion, and there is a guarantee that government will discriminate on the basis of the religion in giving employment. The state-run institutions will neither preach any religion or give religious education, nor will favor person or any religion. What the state-run institution will neither preach any religion or give religious education, nor will favor person of any religion. So, cultural and educational rights. Our constitution believes that diversity is our strength, and therefore, one of the fundamental rights is the rights of the minorities to maintain their culture. The status of minorities. In status of minorities, it is dependent only upon religion and includes linguistic and cultural minorities. Minorities are groups that have common languages or religion and are outnumbered by other social groups in a particular part of the country or in the country as a whole. They have their own culture, language, and script and have the right to conserve and develop this. All minorities, religious or linguistic, can set up their own educational institutions. The government will not, while granting aid to educational institutions, discriminate against any educational institution on the basis that it is under the management of minority community. Now, the rights of constitutional remedies. It means through which fundamental rights could be practiced and defended. Dr. Ambedkar considered the right to constitutional remedies as heart and soul of the constitutions. It is very important here is that right to constitutional remedies is considered as heart and soul of the constitutions by Dr. B.R. Ambedkar. Why? Because these rights gives a citizen the right to approach High Court or Supreme Court to get any of the fundamental rights restored in case of their violations. The Supreme Court and High Courts can issue orders and give directives to the government for the enforcement of right. So what happens? The Supreme Court and High Courts can issue orders and give directives to the government for the enforcement of rights. The courts can issue various special orders known as writs. First one is that habeas corpus. The court orders that arrested person should be presented before it. It can also order to set free an arrested person if the manner or grounds of arrest are not lawful or satisfactory. Mandamus, when the court finds that particular office holder is not doing legal duty and thereby is infringing on the right of an individual. Prohibition, it is issued by the higher court. The higher court means High Court or Supreme Court when a lower court has considered a case going beyond its jurisdictions. Quo warranto, if court finds that person is holding office but it is not entitled to hold that office, it restricts that person from acting as an office holder. Certiorari, the court orders a lower court or another authority to transfer a matter pending before it to the higher authority or court is known as certiorari. Apart from judiciary, many other mechanisms have been created for the protections of rights such as the National Commission on Minorities, National Commission on Women, the National Commission on Scheduled Castes, etc. Now, directive principles of state policy. The constitution maker thought that the moral force behind these guidelines would ensure that the government would take them seriously. What they thought that the moral force behind these guidelines would ensure that the government would take them seriously. They expected that people would also hold the governments responsible for implementing these directives. So a separate list of policy guidelines is included in the constitutions, and the list of these guidelines called the directive principles of state policy. So, why it is needed or what is the need of directive principles of state policy? Firstly, the constitution makers knew that independent India was going to face many challenges such as to bring about equality and well-being of all citizens. Next is that they thought that certain policy direction was required for handling these problems. And next, that they did not want future governments to be bound by certain policy decisions. What? They did not want future governments to be bound by certain policy decisions. The non-justiciable is that these guidelines were incorporated in the constitution but they are not made legally enforceable. That is, parts of the constitution that cannot be enforced by the judiciary. Parts of the constitution that cannot be enforced by the judiciary. So, what directive principles include? It include the chapter on directive principles list mainly three things. Firstly, the goals and objectives that society should adopt and certain rights that individuals should enjoy apart from the fundamental rights, and certain policies that governments should adopt. So some of the directive principles or examples of directive principle is that first on goals. The goals should be welfare of the people, social, economic and political justice, raising the standard of living, equitable distribution of resources, and promotion of international peace. Policies. The policies is that uniform civil code, prohibition of consumption of alcoholic liquor, promotion of cottage industry, prevention of slaughter of useful cattle, and promotion of village panchayats. So what are the non-justiciable rights? Is that adequate livelihood, equal pay for equal work for men and women, right against economic exploitation, and right to work, that early childhood care and education to children below the age of 6 years. So here is some of the examples of directive principles of state policies implementation. First one is that the government passed several zamindari abolition bills, nationalized banks, enacted numerous factory laws and fixed minimum wages. So are these? That Jamindari abolition bills, nationalized banks, enacted numerous factory laws and fixed minimum wages. Several efforts to give effect to the directive principles includes right to education, formation of Panchayati Raj institutions all over the country, and the mid-day meal scheme. Now, fundamental duties of citizens. The history behind fundamental duties and citizen is that they were inserted by the 42nd Amendment 1976 to the Constitution. In fundamental duties, there are 10 duties were enumerated. The Constitution does not say anything about enforcing these duties. But the citizen must abide by the Constitution and defend his country, promote harmony among all citizens, and protect the environment. Does not change the status of fundamental rights. So, our Constitution does not make the enjoyment of rights dependent or conditional upon fulfillment of duties. Thus, the inclusion of fundamental duties has not changed the status of our fundamental rights. So, what is the difference between fundamental rights and directive principles? Fundamental rights restrain the government from doing certain things, and fundamental rights all mainly protect the rights of individuals. In directive principles, it exhorts government to do certain things and it ensures the well-being of the entire society. So, what is the relationship between fundamental rights and directive principles? It is possible to see both as complementary each other, and when government intends to implement directive principles of state policy, it can come in conflict with fundamental rights of citizens. So, what is the history behind it? That rise of problem. When the government sought to pass laws to abolish Zamindari system, which were opposed on the ground that they are violated right to property, the government amended the constitution to give effect to the directive principles of the state policy, keeping in mind the societal needs of the individuals. So here is a long legal battle. For the position of executive, the government claimed that the rights can be abridged for giving effect to directive principles as rights were a hindrance to welfare of the people. Position of judiciary. The court held the view that fundamental rights were so important and sacred that they cannot be limited even for purpose of implementing directive principles. A complicated debate related to the amendment of the constitutions. First, in the government stand on this issue is that Parliament can't amend any part of the Constitution. And the court stand on this that Parliament cannot make an amendment that violated the fundamental rights. What? The Parliament cannot make an amendment that violated fundamental rights. And what is settlement of controversy? It is very famous that in case of Nanda Bharti case, the Supreme Court said that there are certain basic features of the Constitution and these cannot be changed by Parliament. So here is some interesting points from this chapter is that in South African Constitution was inaugurated in December 1996 after the dissolution of the apartheid government. It says that its Bill of Rights is cornerstone of the democracy. In independent organizations like People's Union or Civil Liberties, that is PUCL, People's Union for Civil Liberties or People's Union for Democratic Rights, PUDR, have been working as watchdogs against the violation of rights. NHRC, National Human Rights Commission. It was established in 1993 and the composition of it is that former Chief Justice of Supreme Court of India, a former Judge of the Supreme Court, a former Chief Justice of High Court and 2 other members who have knowledge and practical experience in matter relating to human rights. So what are the Commission's functions include? First is that inquiry at its own initiative or on a petition presented to it by the victim into complaint of violation of human rights. Secondly, it visits to jail to study the condition of the inmates and undertaking the promoting research in field of human rights, etc. The Commission generally receives complaints related to custodial death, custodial rape, disappearances, police excesses, failure in taking actions, indignity to women, etc. But it does not have the power of prosecutions. It can merely make recommendations to the government or recommend to the courts to initiate proceedings based on the inquiry that it conducts. Jyotirao Phule, the time period 1827 to 1890, was a radical social reformer from Maharashtra. So, this is the summary of this whole chapter, and I tried to include all the important points from the chapter. Hope you will like this video. So, if you are new to my channel, then please do subscribe, like, and comment. Thank you.